How can you avoid a contested custody dispute and control the outcome of your case? I think it's fair to say that most people are not excited at the prospect of a long, drawn-out custody battle. So how can clients avoid that?
Well, I think to start, you have to hire good counsel, hire a good attorney, and really heed their advice. This is something that they do for a living. They experience this all the time. So you might come in and you might be really, headstrong about what your position is, but you have to, understand that you're meeting with an attorney for the reasons that you're looking to get guidance. And so it's important to hire a good, experienced attorney, and then not just hire them, but also heed their advice moving forward.
And do you provide the client with information on, any sort of presumption in the law?
Yeah, great question. And we have that brought to our attention a lot. The client's going to say, well, what's going to happen? In other words, what they're asking is, what is the presumption? What's the court going to assume? And so there is a presumption in Wisconsin for both custody and placement. For custody, the law presumes that each parent gets 50-50 custody, that both parents start from the get-go of being capable of raising their child just like the other parent. So that's the presumption. So if you're trying to get away from that, then the burden is then on you to have to show, well, there's this going on and there's that to consider, and then you have to be compelling enough to get the court to buy into that and then move off that presumption. As far as placement goes, it's similar. It doesn't say 50-50 placement, but what it does say is that each party has a right to have meaningful periods of placement with their child, and that could be 50-50. And so if you want to come off that presumption, then again, the burden becomes on you of, well, it can't work for these reasons, and this is why. And so it shifts. But to understand that, hey, this is kind of the baseline we're going to be starting with. And so why don't we try to work around working with that baseline? But if you feel that the baseline isn't going to work for you, then this is some of the steps that you have to go through in order to get off of it.
So what you've laid out for us is, it sounds like step number one is get a good attorney that you trust. Listen to their advice. They're going to give you realistic expectations early on, and you're paying for that advice, so listen to it. And it sounds like, given the presumption in the state of Wisconsin, it's tough to overcome, the presumption of joint legal custody. And although there's not necessarily an exact presumption of 50-50 placement, it's not as though it's common that one parent is going to have 100% placement and the other parent will have 0. Is that fair?
That's exactly fair.
You described this timeline for us, and given the presumptions and the burdens of proof, it sounds like a lot of people may come in originally with a thought of an outcome, but with some good advice and some understanding of what this process truly entails, people may second guess wanting to push through months and months of expensive litigation only to get to an outcome, where a judge is the one making the decision, and that party may in fact be very unhappy with that decision.
One of the things I notice is that when parties come to an agreement on their own, even if that agreement is way different than what they initially wanted from the beginning, they're usually a lot more satisfied, and they're a lot less likely to come back to court or come back and hire an attorney for future custody and placement issues. Whereas when a judge is the one making the decision and there's like a trial and a court order, we then generally see that most people will be returning clients in that sense.
Ideally, you will reach an agreement on custody and placement in your case, finding compromises along the way that you can feel confident are in your child's best interests. The best way to do that is to be very clear with your attorney. What are your goals? Why do you have those goals? What's really important to you here? In addition to telling your attorney what you want, it's also being willing to accept what your attorney is telling you. You hire that trusted attorney because you want them to give you expertise. So being willing to listen to them and accept the reality of the law in this state and how that law applies to your case is going to be really important to help you avoid an expensive, time-consuming, drawn-out divorce process in which you may be very unhappy with the outcome in front of a judge. Unfortunately, Some cases, despite your reasonableness and despite your attorney's best efforts, will land in front of a judge. That may happen in a small percentage of cases. And when that happens, you need to have an experienced attorney who listened to you throughout the process and who you were willing to listen to throughout the process so that you can try to secure the very best outcome on the most important issue in your divorce.
Go to sterlinglawyers.com to learn more about our attorneys. Please take the time to like, comment, and share. Subscribe or follow us for weekly family law content. Thank you for watching this video with Attorney Mullen and Attorney Keenan.